So testing Justice 1, testing Justice 2, testing Justice 3, testing Justice 4, testing Justice 5, testing Justice 6, and testing Justice 7. And testing podium, which seems a lot louder than in the room. Does it sound louder than the justices? No, is it just because I'm here? Yeah. Justice 7.
Sounded a little louder on Justice 7.
So testing podium. So.
Podium sounds good on stream too. That's just where you're standing.
Okay. But it sounds, I'm going to lower it a tiny bit in the main.
I think it's just that well speaker.
No, the well's off.
Oh, it's off. Oh, it's
Well, it's off. No, it's off from the podium.
right, because, yeah, sorry.
So testing 1, 2, 3, 4. So, because there's a little bit of a ring here. And actually, we got some feedback in the bar matters the other day.
Oh, no kidding.
In the bar admissions, yeah.
Huh.
So.
Sweet. Well, you got a good seat.
I do. That's great.
So testing 1, 2, 3, 4. Can you hear me from there? Ma'am? Can you hear me from there?
I can.
Okay, great. Just making sure everything's good. I think it is. Testing, testing. I won't cause feedback by doing this. Is that too loud? Well.
Sound wise, it wasn't bad.
Well, bad.
I mean, we'll see in a minute.
So testing, testing. Yeah, justices come out okay in the main also, I think.
Yeah, I would say so. Good morning. How are you? Good. Jake Blake. Welcome back.
Well, speakers, I think.
Yes, everybody's here early too. Thank you both. Appreciate you as always.
Council, does it sound like this is coming out of the speakers directly behind you?
No. Can
No?
you actually hear again?
Can you hear it? Can you hear it okay?
I can hear it, but
I can hear it from this side.
somewhere over here.
It's coming out from here.
Yeah, it comes out there also. There are 2 little speakers here.
Okay.
We went the whole audio system, so we're still figuring it out.
So let me try.
How you doing, Jim?
I'm gonna do this.
doing? This is a fun one.
I didn't.
No, I think
this
we're
one-
okay
I
on
didn't
the
think we'd be
stream.
here on this one.
first matter this morning is State of Maine versus Lordina, Osei, and this is Cumberland 25-438. We are being streamed on the web, both by audio and by video. I see counsel are present. I'm assuming you're ready. If you would please introduce yourselves by saying your names for the record and the party you represent before we begin the argument.
Good morning. James Mason on behalf of the appellant, Lordina Osei.
Good morning, Graham Whalen for the state.
Thank you. And Attorney Mason, if you're ready to proceed, we're happy to hear your argument this morning.
Chief Justice, Associate Justices, Counsel, and may it please the court. My name is Jim Mason. I represent the appellant, Lordina Osei.
And I see you decided to leave the green light on right from the beginning. Aren't all of your arguments, even those that are really dependent on the facility with the English language, aren't they really all sufficiency of the evidence arguments in this case? In other words, you haven't raised any question about accommodations. You haven't raised any question about the instructions that were given. So in the end, isn't it really just up to the jury to decide whether each and every one of these elements were met?
I agree that yes, this is essentially a sufficiency of the arguments because there weren't specific arguments raised below, but the jury still has to find it beyond a reasonable doubt, and the trial court has to, on a Rule 29 motion, determine if that was met. And this court still does have a standard of review to looking at those claims, and I feel the elements were not met.
But if the issue is really coming down to, did she appear to understand what was required of her, particularly when it comes to the refusal to sign the USC or the summons and the criminal trespass, isn't it up to the jury? Aren't they entitled to make that decision?
They're entitled to make that decision, but it has to be supported by sufficient evidence. And this court, again, reviews those decisions. And when the court is reviewing those decisions, it's going to look at what was there in front of the jury. And what you have is somebody who expressed a discomfort and a lack of understanding in the written
Who expressed
language.
that, but who also, but at least arguably, that was belied by her facility in the language and her ability to express herself.
Yeah, and her ability to express herself in the oral English. So there's a difference, and this court has acknowledged that there's a little bit of a difference. There's a case where they've talked about how we've got to tread carefully.
Is there any evidence besides her own statements at the time?
There was no evidence put in on her fluency or anything like that before the trial level.
Can I ask you about the criminal trespass? I'm curious about what role the handcuffs really played or didn't play in that scenario there. We reach a point where everything that's going to be done is pretty much done, and the officer wants to uncuff her and get her out of there, and she's not compliant. Is the fact that she is in handcuffs at that time prevent her from committing the offense of criminal trespass?
The fact that she is in a police station in handcuffs, and I agree, prevents, you are proposing a question, we're in a statement. I don't believe she has the ability to commit criminal trespass because she can't leave. She can't leave. In fact,
but she's being given instructions on what she needs to do to leave, and that is to stand up to have handcuffs taken off, which she refuses to do initially.
You are correct, but that also sort of underlies the point that she wasn't told to leave. What she was told is to stand up.
Well, at one point she was told, though, very specifically. I agree with you that not every time, but she was, in fact, told, stand up so I can take the handcuffs off so you can leave.
And it's this, but we're still looking at essentially a conjunctive order. She's got to do the first thing first. And if she would have left without having the handcuffs removed, which she didn't have the ability to do, she could have been charged with theft. Given the way that this was, she would have been charged with theft. And she could not fulfill the order at the time it was given. She couldn't. She would have been
The order
stopped.
was to, again, maybe splitting hairs, but the order was to stand up so we can start this process of getting you out of the courthouse, or the police station.
We're absolutely, I understand we are splitting hairs, but splitting hairs is important because not all orders are authorized orders. She was being given an order to stand up. And if she failed to comply with that order, he had other things that he had in his disposal. I mean, he could have had other people come in and lift her up. He could have charged her with obstructing governmental administration. That doesn't mean because she's refusing to stand up, and she's not saying, I'm not standing up, she is talking to him this whole time. But just because she does that doesn't mean she's committing the charge of trespass.
It just add some more confusion to a confusing situation.
Yeah.
It seems like that whole scenario was triggered by him saying you need to sign acknowledgement of receipt of these documents and get back to the language issue.
Yeah.
That's what she's understanding she is or isn't doing. But clearly we see a refusal there. She's still in the handcuffs. To what role does the refusal to sign play in the criminal trespass charge?
There's a thread that you can see in those actions from each one of those. He is asking her to sign it. She is saying, what am I signing? She's saying, this is you saying you're going to come to court. And he's like, I don't understand that. I want a translator. I want somebody to tell me what this is. I want you to stand up so that you can sign this. Well, if you're not going to stand up, I want you to tell me. It continues to build on itself, and it all starts with her asking him to provide her with a translator.
Well, it
to
actually
tell what
all
that document
starts,
is.
it all starts with her talking over him as he's endeavoring to try to explain to her what it is that she has to address.
She was certainly talking over him, he was talking over her. They were both talking at the same time throughout most of the video that we all watched. But she also, during that time, she is expressing, I don't understand.
But she never asks the question about, well, what is it that this says? Or she just says, I don't understand, and then starts saying, no English, and is asking for a translator. But she's never really asking questions about, what is it that you're explaining to me? What does this mean? She's not, it almost appears as if she's not interested in finding out. She's just simply making statements.
To say that the sort of whatever trust that we could theoretically say is between an arresting officer and somebody who's being arrested exists, that was gone. And what she's asking for is somebody to help her understand the document that is in front of her, because she certainly doesn't trust him. And his obligation is trying to get her to sign the summons, and she's asking
Counsel,
for the translator.
did she ever look at the document that was being offered to her?
It was, I'm aware that it was where she was sitting, there's a desk, he puts it down. I think my memory of the video is it's from a distance away, that she wouldn't have been able to read it, nor could she hold it because she was still in handcuffs.
If she couldn't see it, though, and she couldn't read it, then how did she know that she wouldn't be able to understand it?
Because she's expressing to him that she has an issue with the written language of English.
Does she ever say that, Counsel? Does she ever say that she has a problem with written English?
Yes, she did. I don't have a cite from the trial transcripts. What I do remember, she's saying, I have a problem with writing, that's why I use Google, and so I help translating, that's why I'm asking for a
Counsel,
translator.
doesn't this go back to the Chief Justice's first question, which is, she testified at trial. She said, I didn't understand. Isn't it the jury's role to decide whether they believe her or not? I mean, it's not our position to step into the shoes of a fact finder.
No, it's not, except we have to look at it and understand the whole body of the evidence that is there to decide, did they make a reasoned decision? There's just...
But there's certainly evidence, both from her testimony and on the video, from which one could conclude that she's actually quite fluent in English. It almost sounds like you're arguing that if the person says, I need a translator, despite any evidence to the contrary, that is enough.
What I am saying is that if somebody who clearly is using English in a second language, and there was no question that was true, is expressing that there is a language difficulty, I think it is incumbent upon police to at least take some steps to assure that there is no language difficulty with what they are asking them to do. They're asking them to read these written documents.
I understand. So when you say take some steps, I guess that's what I'm trying to understand. What do you think was the officer's obligation necessarily in that situation? Is he entitled to simply assess on his own whether she seems to understand both the written and spoken word sufficiently, or are you suggesting that he must get an interpreter or a translator?
I think if there is any question about somebody's fluency level...
Well, if he didn't have any question in his own mind, is what he's suggesting.
I understand that Officer Knight probably had no question, and I think that was not a reasonable conclusion. If an officer makes a reasonable conclusion that somebody who is speaking in a second language, at least a second language, and is asking to have help interpreting a complex written document. I mean, this started...
But it's a document she hasn't looked at. It's a document she didn't ask to look at.
But this did start with... That was subsequent to the implied consent form, of which he tried to have her read, and each time she was saying, I don't understand. And so even before we get to that point, because the refusal to sign the summons was for the OUI, so even when we get to that point, we have evidence for the officer to have made a conclusion that he needs to assess whether she actually does. And he just simply is like,
Why can't he base this assessment on the 45 minutes he spent with her where there was no indication that she had a language issue and she didn't ask for an interpreter?
Because as soon as we got into written documentation, she did. And there were a few points during the process, particularly during the field sobrieties, when he was asking her to do 1,000, 1,000 accounts. She's like, I have a trouble with that. But this is not my first language. She said that out on the street. So he was aware that this was going on. So he had enough indications that he should have done more than just, I don't believe you. And I think that's really what he did.
Can we go back to the criminal trespass? I want to see if I understand your argument. Is it that just on the particular facts of this case, the jury could not have found it beyond a reasonable doubt? Or are you suggesting that as a matter of law, when someone is handcuffed in a police station, they really can't commit criminal trespass?
I think that there is First, I would say that if you are handcuffed in any sort of secured facility, you cannot commit criminal trespass. This could be if you're in prison and you are in a room where you are being directed by a corrections officer to leave the room, you're not committing criminal trespass if you don't leave that room. But in this particular case, that when you go through the analysis of the elements, it fails at every step, even from the fact that didn't order her to leave, he ordered her to stand up.
So looking at the elements, I guess what would you say your strongest argument is as to the element that's not met? Is it that there was just not an order to leave, or is it that she wasn't sort of refusing to leave because she was detained, essentially?
I would say that first it's that it wasn't a lawful order because she was handcuffed. And second, I don't believe it's clear there was evidence put before the jury that he was authorized to issue a criminal trespass order. That is a required element, and you can't. The state didn't raise at trial that he has implied authority, and this court in Sanchez said we're not going to address it here. He didn't even raise it in his brief. I don't believe that there's any evidence that he is authorized to do so, particularly when you go back to. She's handcuffed and cannot leave, and therefore that's not authorized. I think the lawful order is our strongest of those, but I don't see how he makes any of the elements.
Any additional questions from the bench? Thank you, counsel.
Thank you.
And Attorney Whelan?
Good morning, Justices, Chief Justice Stanfield, and counsel. May it please the court. In the matter of State versus Osei, the jury found Ms. Osei guilty of all 3 counts brought by the state based on the evidence presented, and this court should affirm that verdict. The primary issue raised on appeal is one of translation services. with the appellant asserting that the jury did not have sufficient evidence to convict Ms. Osei given her language limitations. However, the jury watched over an hour of video of Ms. Osei speaking with Officer Knight on February 13th, 2022. They heard Officer Knight testify that her English was 100% perfect and that her phone was set to the English language. And they noted that there was no translator at trial because Ms. Osei did not request one. Given that no translation services were required, there's no basis for this court to find fault in the jury's verdict. I invite questions.
Let's look at the criminal trespass. I mean, this is a woman who, even taking it from the state's point of view, that essentially she was being obstructionist and over-talking at that point. I mean, really what he keeps saying is stand up. He doesn't say leave. I think he doesn't most of the time. He eventually does, but they're all talking over each other. I mean, how is that clearly communicating, personally communicating a lawful order to leave? I mean, they're basically arguing. I'm not saying, like I say, even assuming that she's essentially being obstructionist, I mean, there has to be beyond a reasonable doubt a lawful order to leave and that she remains in place in defiance of that order, knowing she can't. She's handcuffed. She's seated. And he tells her repeatedly to stand up, but he doesn't repeatedly tell her she needs to leave, and if you don't do so, you know what I mean? It's
I understand Your Honor's concern. If we go through this element by element, she's remaining in the Portland police station in defiance of a lawful order issued to her by an authorized person. So let's start with authorized person.
But is it that? But that's the question. No, the order. Okay. Where's the order to leave? His order is stand up.
So the jury found that based on the multiple times Officer Knight asked Ms. Osei to stand up so that he could remove her handcuffs. He can't remove her handcuffs while she's seated. So the first step is you need to stand up so I can take off your handcuffs and then you can go. You need to leave. And he says you need to stand up. And it's clear to both the jury and to Ms. Osei that the reason she needs to stand up is so we can initiate the process of her leaving the Portland police station. And then he says, if you do not stand up, you'll be issued a criminal trespass order.
But most of what you just argued is by implication, is my point. And I think the criminal trespass statute isn't by implication, is it?
Well, no, Your Honor, but he did, as Your Honor noted, he did say at one point, you need to stand up so you can leave. If you don't, you'll be given a criminal trespass order. That's explicit. And even though most of the interaction and back and forth, and it's not like we're talking about somebody who's a very active listener at this point, but most of the back and forth is him, Officer Knight, trying to begin the process of getting her out of the Portland PD. And that requires her to stand up so he can remove her handcuffs.
So you're arguing that the stand-up order was a predicate that was intertwined with the order to leave?
With the one-time explicit order to leave, yes, then it would be the first step toward that order. Yes, Your Honor.
I mean, is it the wrong charge? Attorney Mason said that maybe the right charge, if she refuses to follow the order, refuses to stand up, is, obstructing government administration or something like that. Maybe you could do a disorderly conduct. It feels a bit like a square peg, round hole when she's literally handcuffed. I mean, she cannot leave at that moment. So I'm still struggling. I understand that there's a multi-step process that the officer's trying to get her to engage in, but it still seems a little divorced from the meat of what criminal trespass is about. Do you understand what I'm saying?
I understand, Your Honor. I agree with counsel that splitting hairs is important, especially at the appellate level, but I don't think that to say that she was not free to leave, I'm not sure is accurate at this point. He's saying it's time for you to go. She is free to leave if she just stands up and lets Officer Knight remove her handcuffs. At this point, Officer Knight wants her to leave, so she's very free to do so if she would simply stop yelling for translation services.
Let me just tee up a hypothetical just to break this down. A person is in a place and they receive a lawful order to leave, but they're in bare feet and it's 10 below zero outside and snowing, so I can't leave without anything on my feet. And they say, no, leave, you have to leave, but there's a practical impossibility between the order and the act itself. Is that criminal trespass?
If somebody is in a situation where, in order to leave, they would be endangering themselves, I think it would be hard-pressed to find that that's criminal trespass. So that's obviously not what we have here.
If there was a conditioned precedent that involves danger, then you would say not criminal trespass. And in this case here, there was no conditioned precedent standing up that involved danger? Is that the tipping point?
I think so.
Okay.
Counsel, what does the police department normally do in a situation where you have a person in custody whose first language is not English, it's the middle of the night, and we have the exact same scenario? Is there a policy that the department has to have a translator available?
I'm not an expert on their policy. I will say that in my many reviews of Portland police actions, there is a language line available. And so if it's deemed appropriate, officers can call a 24-hour hotline that usually has any number of translators available. That was not the case here because, as noted by most of the panel's question, Ms. Osei's English was perfect.
Okay, but
Right,
here's
so
the
it
problem.
is available, the language line is available, was available to Officer Knight.
Yes.
He could have accessed that and used it.
He could have if he found it to be available, if he found it to be appropriate, yes. And that was he testified at trial that he did not find language services to be required based on her proficiency in English and also her willingness to participate in the process at that point. If he had a translator, it was every indication that she would continue to yell over both him and the translator.
Is there a practical issue here? Can the person on the other end of the language line read documents?
I mean, that certainly would be difficult. I mean, as noted by Justice Lawrence, because Lawrence's questions, she was never really given the opportunity to view. We're not talking about an individual that's struggling to comprehend officers' instructions. She's not asking him to repeat himself more
But this
slowly.
is the problem, is that oral spoken English, which may or may not require an interpreter, is different than written English, which may or may not require a translator. Two different things. She didn't ask for an interpreter. She didn't ask for assistance in understanding the spoken word. She asked solely for assistance in understanding the written word. And what was the basis upon which he could conclude that she understood written English as opposed to oral English?
I think he was relying on her obstructionist nature because she did not request translation services until the uniform summonses came out.
But let me be clear. Translation, it means, by definition, a written document. It is not oral interpretation. She was being quite precise there. She didn't need a translator, from her perspective, until there was a written document.
With respect, Your Honor, she didn't ask for a translator until the second written document. The first written document was the implied consent form, and that's the one that she spoke over Officer Knight during the reading of every paragraph, reiterating the fact that he had taken her out of her car without her consent. So at this point, he's already tried to review one written document with her, and she's saying that she's not cooperating at all. She's making no effort to understand it. Then he brings out a second written document, which is the uniform summons and complaint for OUI, and at that point, she asked for a translator. At this point, in addition to her proficiency and fluency in English, he determines that it's not appropriate to use more time and resources just because she's intoxicated and is choosing to obstruct.
And is that a jury question at that point?
I believe that is a factual determination, absolutely. She testified, she waived her Fifth Amendment right in English without a translator before Justice McKeon, and she testified that she wanted a translator, but the jury watched an hour of video and they were able to make a determination as to whether or not she actively refused what Officer Knight was asking her to do, both in submitting to the intoxilizer and in signing the VSACs. That's a factual issue for the jury. And that's why I said in my opening remarks, there's nothing here that's language-based that this panel could rely on to overturn that verdict by the standard of review.
Counsel, wasn't there evidence as well that her phone, all of the written information on her phone was in English?
Yes, when Officer Knight first approached her, she was speaking to her passenger in English, and when he had to review her phone, he noticed that the default language of the phone was set to English.
So he had that information available to him when he was making an assessment about whether a translator was needed?
Absolutely.
And the jury heard that information, is that right?
The jury did. He testified to the fact that her phone was in English, and obviously most of the communication on a phone is written.
Also, he took the phone into possession at the police station, did he not?
He had it. When they were in the intoxilizer room, yes, he had it.
She actually had pulled it out, and I think he took it away from her, if I remember the video.
I think so, yes.
Any additional questions from the panel? Thank you, counsel.
Thank you.
Attorney Mason, you've reserved 2 minutes for rebuttal.
Thank you. What Officer Knight said when it came to ordering her out is says, okay, now you're delaying this, so I'm warning you for criminal trespass, because now you're trespassing here. If you're not here for any good reason, they spoke. This is your warning. You have to stand up so I can take your handcuffs off now, so I can let you go home. And if you don't do that, you're going to be staying here, which is criminal trespass. There was no order to leave. The only time he, in fact, ordered her to leave was after he had taken off the handcuffs and he said, go. And she's like, what did you say to me? I said, go, get out of here. And she left. So the only time she got the order, the direct order to leave, she complied with it. And until then, as she said at trial, she was in handcuffs, which meant she didn't think she could leave, because in fact, she couldn't. The state says we really need to be able to assess her language skills. It wasn't until these written documents came out that she was asking for an interpreter. The fact that she didn't ask for a translator, an interpreter at trial 3 years after this took place shouldn't be held against her.
So you just said she didn't think she could leave because she was in handcuffs. So when the police officer said, I need to take your handcuffs off so you can now leave, wouldn't that kind of be a clue to her that it was time to leave and now the handcuffs were coming off so she could leave?
The handcuffs, so again, this is still all being put in the context of where they are discussing the fact that she wants a translator for the documents that he's putting in front of her. And she is still, in each one of these, she's talking about asking for a translator. She's talking to him. She's talking to the video camera up in the corner, trying to talk to somebody who's ever listening there.
Well, by the time that she's asked, or that he's telling her that she needs to stand up and she can go, it's obvious that she's not signing anything at that point in time, and so her asking for a translator is no longer really viable or necessary.
If I may respond.
You may.
She has clearly put up all sorts of barriers for this, but the fact that she might have signed it when she was able to, when her hands weren't handcuffed behind her back, was still an open question. She had, I think, because she could not do it, nor could she understand what was in that written document that she was signing, that's not enough to convict her of these charges. Thank you.
Thank you.
Follow-up question?
Yeah, go ahead.
But to the extent that he was telling her, you need to stand up so I can take your handcuffs off so you can go, by implication, he's saying, you've indicated you aren't signing this. The only thing preventing you from leaving is standing up so I can remove your handcuffs.
He is saying that, but he is also saying that in the context of he wants her to stand up to sign the citations, which again, she hasn't indicated that she's going to, but she's not capable of doing so either.
Any additional questions? Thank you, counsel.
Thank you.
As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter. seated. The matter before the court is the town of Sabattus versus LP Poirier and Sons. This is Andrew Scoggin 25441. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. And I would ask counsel who are arguing to introduce themselves for the record together with the party you represent, starting with the appellant.
Colin Hull, representing the appellant, the Neighborhood Abutters Group.
Eamon Hart, representing appellee, the town of Sabattus.
Thank you. And Attorney Hull, if you're ready to proceed, we're happy to hear your argument this morning. It's my understanding that no other party is intending to be heard at oral argument. Is that correct? Okay.
Good morning, and may it please the court. This case presents a straightforward legal issue. The district court erred when it entered and accepted a consent judgment that is inconsistent with state minimum standards, and this court should vacate that decision as a result. Although towns are afforded some prosecutorial discretion to settle litigation, Pike sets limits on that discretion, making clear that courts cannot accept consent judgments that violate applicable laws and other authority. Pike requires consistency with all applicable statutes, not just the ones that towns might have primary enforcement over, because it is the district court that must ultimately enter and accept that agreement as its own order. Here, the consent judgment fails that standard, the standard under Pike, because it sanctions a buffer that is less than what is required under state law and the town's own ordinances. The abutters who have a direct interest in the property at issue are merely insisting that at a minimum, this agreement meets those basic standards. Accordingly, we ask this court to vacate the district court's acceptance of the consent decree and direct the parties to reach an agreement that is consistent with the minimum legal requirements. I welcome your questions.
This is on an 80K complaint, right?
Correct.
Could the town, let's assume this 80K complaint went to hearing. Could the town, as part of the relief sought under 80K, force compliance with state laws that are not incorporated into town ordinances?
I don't believe it could through an enforcement action.
And isn't it really state laws that you're concerned about here?
It is state laws that we're concerned about, but in Pike...
What is the power of the town to force compliance with state laws? Putting aside whether it's in the context of a consent decree or whether it's in the context of a final contested judgment.
I'll admit that towns can only enforce laws that they have direct or primary enforcement authority over, but here in the context, it's actually a district court's decision approving a consent judgment. And the question that Pike lays out is all those, they're only responsible, or they need to make consistent only those, all applicable statutes.
But it seems that what you're then arguing is that if you're going to do a consent judgment, the district court has to put a more rigorous review on that to find compliance with state law, which the district court couldn't even order if it went to a contested hearing. I mean, that Pike can't mean that, can it?
Well, first, in this case, we know that what laws apply. We know that because it's a gravel pit, there's mining involved. We know that there's a state law related to mining. The DEP did a survey in which it found 5.7 acres had been disturbed and affected and extracted. So it's
Counsel, can I ask you about that? So
Sure.
there's a map in the appendix on page 233 that was from October of 2024, and there it says that the approximate limit of the excavated area is 4.65 acres. And I don't think either party cited to that diagram, and I'm wondering, that seems significant, that diagram seems to be saying that the excavated area is 4.65 acres. And so I'm wondering if you could shed light on that.
Sure, yeah. We're not totally sure what that 4.6 acres refers to. And in the findings of fact in the consent judgment, it says 5.7 acres, so.
Well, it says
that's a
5.7 acres was found to be affected. It doesn't mean that that's the excavated area, and those may be two different things.
Though I think that distinction is hair splitting. There's no sort of basis to conclude that there's been any other use other than extraction and excavation.
Well, are there like outbuildings or storage areas or other kinds of things that are surrounding the excavated area?
Not to my knowledge, and I don't think that was part of the record at all before, or certainly not part of the findings of fact that were entered by the district court that were part of the consent judgment.
But isn't the size of the project here a critical tipping point here? It makes a big difference, right, as to what applies and what does not?
Right, yeah, so.
And isn't that a critical finding of fact that would have to appear in the record in order for us to determine, yes, this does apply, no, that doesn't apply?
I think that is actually part of the record because it is within the findings of fact of the consent judgment itself. And when the district court entered that consent judgment and entered that order, it adopts those findings of fact that are within the consent judgment.
So is that finding of fact supported in the record here? Can we look to the record that would definitively tell us what the actual dimensions of the project are? The map was referenced just a moment ago.
The map was referenced, but within the findings of fact, it's listed. So it's taken as a conclusion, and it just becomes a straightforward legal argument.
There was no hearing here, though, was there? There was no evidentiary hearing?
There was no evidentiary hearing. There was oral argument.
Was this stipulated? Were these facts stipulated then?
When they are findings of fact within the consent judgment, and by reference, the things that are referenced within it, those are the factual record that the court considers as part of the consent judgment.
But the judgment itself does not actually make a finding of 5.7 acres. What it says in paragraph 13 is that the DEP notified the town and completed a field survey, and the results showed that the, quote, affected area is approximately 5.7 acres. Then in paragraph 15, when the actual violations, the agreed to violations are listed, it is simply that it has expanded beyond 4 acres. It doesn't say it's expanded to 5.7 acres. It says it's expanded beyond 4 acres, and 5 acres is the tipping point for state law, isn't it?
Right. There's no reason for, or the acknowledgement of the DEP survey, there's no question as to the reliability of that information, and by including that within.
As we say to judges all the time, reciting what the evidence is not the same thing as a finding that it is true. And that's what this is, really. It is a recitation that this happened. It doesn't say it was true.
Right. Yes, there's no evidentiary hearing, but it's important to emphasize in the limited record of what the court is adopting, they receive the consent judgment.
Is it your argument that it's effectively a stipulation by the town and Poirier that these are the facts and that therefore they're sort of bound by their stipulations? Is that your position?
Right. It's effectively, although they probably would differ with what they would describe it as, but it's effectively by including it within the consent judgment in the factual section. That's essentially we're agreeing that yes, it's 5.7 acres.
Counsel, do you agree that the consent order expressly requires Poirier to perform the reclamation work in accordance with state law?
Yes, it does. It does require that. Yes.
And part of that state law are going to be the performance standards in section 490-D, right?
Right. Correct.
So if those standards do in fact apply to this reclamation part of the work, Poirier is going to have to comply with those standards, correct?
The problem here, and it doesn't go far enough to just say, oh, Poirier must comply with all applicable or state standards or whatever that language is, because the consent judgment sanctions Poirier to.
Well, would the consent order, so the consent order says that the buffer has to be 30 yards, right?
30 feet, I think.
30 feet, I'm sorry,
Yeah.
thank you. Is there anything in the consent order that would prohibit Poirier from doing a 50-foot buffer?
There's nothing in the consent order. I think, yeah, you're correct that Poirier could do a 50-foot buffer, but the fact that it allows Poirier to proceed with the 30-foot
But I guess what I'm asking is Poirier wouldn't be violating the consent order if he created a 50-foot buffer, correct?
No, I don't think he would be violating the order, but the fact that it allows or sanctions him or sanctions that activity, that reclamation, to those standards is about whether it is meeting the minimum performance standards that are required. And by including only a 30-foot requirement, it doesn't go far enough.
I have a sort of question about Pike and what it means when it talks about element 3, that the consent decree will not violate, statute, other authority. What, in your view, is the town's authority? Because the purpose of a settlement, right, is that they're giving a little bit, the other side's giving a little bit. They're not getting everything they want. Can they agree to anything that does not sort of fully satisfy, for example, the town ordinance? Or is it your position that they just don't have authority to do that, either under Pike or their own ordinance?
I think there are limits to what they can settle, and if they allow things that are less than the minimum state requirement, that frustrates a state purpose, and that's sort of the basis. It's tailored to and connected to like a preemption sort of idea.
But would the state have the prerogative to step in and say, whoa, we need 50 feet here? I mean, the town is satisfied, we got the 30 feet, that's fine, but couldn't the state step in after the fact and say, we know you agreed with the town for this, but as far as we're concerned, we need the 50, so we've got to do that.
Right. The fact that the DEP could get involved is true, but that doesn't necessarily, that's not relevant under sort of the Pike analysis, which is asking the district court to do
I'm
something.
still struggling to understand how the town, would have the authority to require Poirier to comply with state law if it's not a standard that is not incorporated as part of a town ordinance.
The distinction here is that it's actually the district court that is entering and accepting.
Yes, but that brings me back to my very first question. How on an 80K complaint does the district court have the power to order anything that the town doesn't have the power to seek?
The way you arrive to a consent judgment through an 80K or any sort of notice of violation or whatever that they've agreed to, it doesn't matter under Pike. It really, the question is, may I briefly finish here? Yeah, the question is whether it's applicable with state law here. And so it doesn't matter, I think, whether or not the state or the town has that enforcement authority. It's ultimately on the district court to make sure it complies with state law.
Thank you. Any additional questions from the bench?
Can I just follow up on the last question you and Justice Lopez asked? This is a settlement. And at the bottom line of your argument, are you saying that as a matter of law, that the town cannot agree to anything that is less than what the state regulations require?
If we know that law applies, it needs to be at least consistent with the minimum requirement. So perhaps if Poirier or if the consent judgment had said, or had set no limits on what the buffer could be, but not given that number value, this could have been different.
I'm not following you.
Sorry, had the town not and then by extension the district court not sanctioned 30 feet as the minimum requirement for the buffer, which we know is under that performance standard, or is less than that performance standard, that's not far enough, or that doesn't satisfy the requirements and it's inconsistent with state law.
So your answer is that the town can't agree to something that is less than the state's requirement?
Correct, yeah.
Okay.
If it's applicable, yep.
Any additional questions from the bench?
One quick question before you leave. Are your clients arguing that the consent order violates the town's shoreland zoning ordinance? And if so, what provision do you allege is being violated?
The consent judgment, there's not like a direct conflict. Well, it does apply because it's within the shoreland zone, and so it's an applicable set of standards. But here, the problem is the buffer and the distance of the buffer that we've identified as the legal issue.
So just to be clear, though, you're not arguing that the order violates any specific provision of the shoreland zoning ordinance?
Not directly. It's implicated by the statute. It's applicable or under the consent judgment, but our problem is the buffer. So thank you.
Thank you. And Attorney Hart, we're happy to hear your argument.
Thank you. Good morning, Madam Chief Justice, Associate Justices, and may it please the Court, Eamon Hart on behalf of Appellee, the town of Sabattus. As we just heard, the appellants are asking this court to set aside a consent judgment that the district court entered resolving land use violations in Sabattus. And the principal contention seems to be that the consent judgment violates state law. And that is premised on what I would call a category error. And I think it came up in the colloquy that was just had right now. Municipalities have no role in investigating 490D violations, assessing them, enforcing penalties. There is no role. This DEP enforces that exclusively. There's one exception, which is under 490I, municipalities can register to become the enforcer. Sabattus has not done that here. So because Sabattus has no enforcement authority, it follows that nothing Sabattus does waives or somehow renders inapplicable 490D if it is in fact applicable to this site. If DEP were to go out there today with surveyors and determine that it is a violation of 490D, Poirier can't hold up the consent judgment and say, oh, no, I'm immunized here. In fact, the consent judgment says the reclamation work there has to comply with state law. And what I think we just heard in the colloquy just now is the contention that a municipality can't settle via consent judgment a violation where there's some colorable violation of a state law that the state enforces. That doesn't work for a couple of reasons. One, it would disrupt the statutory scheme, right? As I mentioned, there is a provision by which municipalities can become enforcers. Sabattus hasn't done that here. So if this court were to rule that anytime there's a consent judgment, that somehow means a municipality has deputized itself to be the enforcer, what would be the point of 490H and I? The second issue is a practical one, right? A lot of municipalities simply aren't going to have the resources to sort of independently investigate what might be state law violations. They have a hard enough time with land use as it is, right? So the idea that now, anytime there's a consent judgment, we have added a whole layer of additional enforcement activity that the municipality has to do, despite the fact that, again, there's no statutory role for the municipality here, it'd be very disruptive to municipal governance. And the final thing that I think the colloquy just now was illustrative of is, in an 80K action, what's being adjudicated or settled by consent is the land use violation. The application of a state statute that DEP enforces isn't before the court. So to bring it to the facts of this case, we've had the colloquy about, okay, well, is affected area the same as total excavated area under the statute? That question wasn't even before the court below, nor could it have been, because again, the municipality isn't the enforcer here. So you end up...
Well, this is the part I don't understand. This started with an 80K, correct?
Yes.
So the town said that the land use owner, the landowner was violating, it could only argue it was violating the ordinance.
Right.
So there were 4 violations that were identified, correct?
That's correct, yes.
So the violation of the reclamation plan, it went beyond 4 acres, yada, yada, yada.
Yep.
Correct?
That's correct.
So this settlement doesn't cure any of that, does it?
Well, I think it does. I mean, the slope gets regraded
But to the exact same berm?
2.5 to 1.
So you're saying
Which
they agreed completely to comply with that?
I mean, the consent judgment says they have to comply with applicable zoning ordinances, and it sets out specific requirements about it's going to be a 30-foot berm, it's going to be, I believe it's a 2.5 to 1 slope, And there is a reclamation plan that you kind of have to dig through the record to get to it, but it's in Exhibit 6 of Poirier's filing with the district court below, which adopts, by the way, the standards from the shoreline zoning ordinance.
So are you saying that there weren't any violations in the first place?
No, there were. They expanded beyond 4 acres, which was what was conditionally approved, right? So 2003, there's a conditional approval that says you can do your gravel extraction on 4 acres.
So it's beyond 4 acres.
It's beyond that.
It exists beyond 4 acres. They don't have a duty to fill it in or anything like that.
No, and because a land use violation, when it's resolved by consent judgment, right, there is prosecutorial discretion and there is the ability to settle, as we've talked about under Pike.
Right,
So,
I'm just trying to figure out what parts of their violations that you identified were a part of this compromise. And then I'm trying to figure out whether that compromise is allowed under the ordinance that says the agreement to settle shall not allow an illegal structure or use to continue unless there is clear and convincing evidence that the illegal structure or use was constructed or conducted as a direct result of erroneous advice, which was never presented. So if there was an illegal structure or use that you're claiming there was a violation of at the beginning of the 80K, how was that not violated when you settled?
So I'm glad you asked, because the shoreline zoning ordinance is important here, right? So that language you're referring to is from the shoreline zoning ordinance. And it says that the municipality cannot settle a violation of that ordinance, leaving a continued illegal structure or use. So the first problem with that argument that they made in their brief is the violations here, 3 of the 4, don't relate to the shoreline zoning ordinance, so that language isn't even implicated. Now, the second issue is the one that did relate to the shoreline zoning ordinance was
Which is
the
what?
expansion into the shoreline zone without planning board approval. Expanding into the shoreline zone isn't a per se violation of the ordinance here. They just needed planning board approval and they didn't get it. So the remedy would essentially be planning board approval, which would require a reclamation plan. Here they got a reclamation plan. So, and the reclamation plan mirrors the requirements in, I think it's 15M of the shoreline zoning
But
ordinance.
was there a reclamation plan at the beginning when this site, when the gravel pit was first put in?
Under the conditional approval, there was an original reclamation plan.
And this violates that plan, correct?
Well, the use violated 4 elements of the ordinance, the 3 of the conditional approval and 1 of the shoreline that we were just referring to. The reclamation plan, what the town did is it recognized that, okay, we're 20 plus years later, the original reclamation plan may not work. We're going to
Because they violated it, right?
Well, I wouldn't say they violated the reclamation plan per se. What they violated was expansions that they weren't supposed to do, and then on an 80K, we're looking to resolve that violation. So it's not so much that, oh, here was the 2003 reclamation plan.
But has it been resolved by the illegal use being cured, as the ordinance language seems to require?
So that, going back to that, that's a whole...
You said that ordinance language is only the
only
shoreline
applies to the
zoning,
shoreline.
and that part is being resolved?
Yes, because there's a reclamation plan that's fully consistent with the shoreline zoning ordinance requirement. Now, the other thing I want to speak to, though, because this, I do think it's important, is, and the party's positions are pretty clear in the briefs on it, the town's position is there isn't an ongoing use here, right? There is a distinction between a use and a violation. Here, the consent judgment is explicit. There's no right to further extraction. There's no right to further use of the property.
Could this settlement agree to have no buffer at all?
Standing here today, I don't know. That might not be acceptable just as a practical matter for the town or for safety reasons.
Why not? Under your analysis, they wouldn't have to have any buffer.
Actually, I think the town would want the buffer and it would want the slope because that corrects the original problems, right? The original,
okay.
Right, which it gets. It doesn't get a 50-foot buffer that the appellants want, but it gets a 30-foot buffer and it gets a slope.
And you're saying that's consistent with what was required at the time of the initial approval that they've now violated?
Yes.
Well, no, I didn't follow that. It doesn't comply with what they originally were supposed to do?
So they were originally supposed to not expand into shoreline zoning, not go beyond the 4 acres, not expand into the buffer zone, and maintain a 2-1 slope.
And what was the original buffer zone?
As I stand here today, it's not coming to my head whether it was 50, 100, or
feet
30.
and 100 feet of the right-of-way. So it's not complying with the
yeah.
buffer that was originally a part of the approval of this use or structure.
My co-counsel refreshes my recollection, it's 100 feet. So I agree, it's not 30 feet is less than 100 feet.
So it's not complying with the original structure or use approval.
Yes.
That's why I get a little confused when the language of the ordinance says, albeit only for the shoreline zoning, says you can't settle when it's the continuation of an illegal use or structure.
Well, and again, it's shoreline zoning, so our position is that isn't even applicable to that
Even
violation.
though it went into the shoreline zone.
Right, which has been cured, because the issue wasn't that they went in per se, it's that they went in without planning board approval, which would require a reclamation plan. They've now gotten that reclamation plan approved.
Which is different from the original reclamation
From
plan.
the original, but that doesn't mean that there's a violation, because had they gone in and expanded, I mean, they would have needed a reclamation plan. There was an original one.
And when I asked you, okay, so let's look at the site plan approval and the site plan ordinance, and I said, can they have absolutely no buffer under your analysis? Your answer, I think, is yes, they can have, that you could have settled with no buffer whatsoever, even though the site plan approval originally called for a 100-foot buffer.
Well, and what this comes back to is, again, site plan approval isn't really the inquiry for settling a violation, because site plan approval is about new uses. So the 2 ordinances that they cite in their briefs are the 2004 and 2015 site plan reviews.
Focusing on...
You're talking past each other.
Yeah.
I mean, I'm focusing on the ability to settle.
Right.
Okay.
If I understand you correctly, and maybe I'm boiling this down too far, but I think you're saying that the town has the prerogative to settle on any terms, even if they're inconsistent with the original site plan approval?
I think that's correct, as long as there's not, an ongoing use that violates the ordinance, which there isn't here. There's no ongoing use.
But how does that square with Pike? Let's say the settlement clearly violated state law, putting aside enforcement authority, who has the authority to enforce or not. Suppose it clearly violates state law. Can the court approve that under Pike?
It clearly violates state law. Does it clearly violate a state law?
I want you to assume that it does. Can the court approve it under Pike?
The court can't approve that, but...
Right, so suppose here there was a finding that the excavated area exceeds 5 acres. And the law, state law, is specific about the requirements for that. How can, without a finding in the record, how can we act on that?
So 2 things I would say. 1, let's assume for the sake of argument that there was actually a finding that says there's 5.7 acres of total affected area. I still don't think this consent judgment presents a problem, because it doesn't restrict the state from enforcing that, and it in fact requires compliance with state law.
But it's about what the court can approve.
Sure. I still think the court can approve it, because the question of whether it's illegal, I think, doesn't go to what the number of feet is. It goes to whether the state is restricted from its purpose, which in this case it wouldn't be.
Was the state a party to any of these proceedings?
The state wasn't a party. The state's aware. I mean, the state, as you saw from the record, the state had
If they weren't
surveyed
parties, my next question is, are they bound by anything the court has said? Have they been cut off saying, whoa,
No.
something here says only 300 feet here?
No, they're not bound. And in fact, quite the opposite. Poirier, by adopting the town's position below in his brief, Poirier's stopped from any assertion that the state can't enforce against him. So,
would your position be different if the consent decree said the buffer must be 30 feet and no more? Does it turn, in other words, on the fact that I think you're arguing that 30 feet is a floor, not a ceiling, but what if it said it may not exceed 30 feet?
I think if it said it may not exceed 30 feet, it would be a closer question, because if it couldn't exceed 30 feet, And if the state determined that the requirements of 490D were triggered, then you would have a flat inconsistency, right? Poirier couldn't comply with the consent judgment and simultaneously comply with state law.
So it doesn't turn just on who has the enforcement authority. It does turn to some extent on, in your view, whether there's sort of a direct conflict between what the town is requiring and what state law requires?
That's true, but that is in and of itself sort of dependent on enforcement authority, right? Because
even if they say it may not exceed 30 feet, you know, they're still not enforcing state law, right? So but then Poirier is in a position of...
That's a tough bind
Right.
for Poirier. Yeah. So I think that would be problematic. There's a reason the town wasn't going to enter that consent judgment. And, you know, one way to think about it, I know my time is running short, but, you know, imagine this consent judgment hadn't said anything about how many feet of buffer, but instead it said, you shall correct this consistently with state law, and DEP shall be the determinant of that. That's a worse outcome for the abutters any day of the week, because it really doesn't require, you know, it doesn't provide town enforcement, and I see my lights coming on if I
finish
may
your
finish my
sentence.
thought. It doesn't provide that the town can enforce, it relies instead on the state, but I don't think there'd be any reasonable argument that that's inconsistent with state law because it would expressly incorporate it. So that's why I think the position is a little bit odd here to say it has to mirror state law when you could have a version of this that's worse for the abutters that more clearly embraces state law. I'm happy to answer any other questions, but I see the red light's on.
Are there additional questions?
Yeah, may I just inquire, we didn't touch on this during your argument in chief, but the town is arguing that the statutes only apply to operations larger than 5 acres? That's your position? I mean, that would be a kill switch to the...
Right, and that gets back to, I think, the first colloquy you had with opposing counsel, right? The question of what the total excavated area is wasn't adjudicated and wouldn't be adjudicated before the district court in an ADK proceeding.
Well, that's actually the question I'm leading up to. Before you can activate this kill switch,
right,
there would have to be a finding regarding the acreage here.
There would.
Seem to have agreed. It floated through with the greater than 5 acres numbers, and then the court sort of stamped that no evidentiary hearing is held. As the town was arguing for this very powerful, I'm not going to call it an affirmative defense, but something that would stop it in its tracks, wouldn't the burden be on the town to be showing to the court or to the parties or establish somewhere in the record that it is less than 5 acres?
I don't think so for 2 reasons. One, again, it's not adjudicated whether affected area and total excavated area are the same thing as a matter of law. The second issue is, even if it were the case that the town said, hey, we'll agree that the total excavated area is more than 5 acres, it still wouldn't, the settlement agreement doesn't waive anything because the town's not the enforcer.
But how can we, actually this is my penultimate question. Getting there, if we're in edgewise, for we as the reviewing court, how can we get at that issue that you were floating to us? How can we get our hands on it?
I think you can't, and that's the problem, right? Is that if the requirement becomes, okay, in an 80K, you have to adjudicate all these state law questions where the town isn't even going to be enforcing it and it's not presented to the court, then you're creating a whole lot of extra work for district courts, which isn't really meaningful because the enforcer's not there. And I mean, can I answer? I know my light's on, but if I'm satisfied here.
It's up to the chief. She brings the curtain down, not me.
Well, his question was, has he answered your question?
Yeah.
I think you've answered it as best you can.
Any additional questions from the bench?
Counsel, can I just ask sort of the same question that I asked counsel for the appellant about this map in the appendix that talks about the approximate limit of the excavated area? I don't think you cited to that in your brief, and I'm just wondering if you can shed any light on whether this map has any significance or not.
233?
Page 233, yes. And there's a marking on it, I think this is from October of 2024, and it says approximate limit of excavated area, 4.65 acres.
And as I stand here, I'm not recalling specifically which exhibit this came from. I mean, again, I think it's illustrative of the problem, right? Is that this question, does it meet the statutory requirement for 490D, wasn't presented. There was no evidence raised on it because it wasn't relevant to the proceeding. So at this point, we can't say one way or another, and there's no reason you have to in an 80K. And you'd have this oddity, right? If, let's say, it was adjudicated, but DEP isn't there because DEP is not a party, DEP could show up the next day and say, yeah, actually, we looked at it, and yeah, the whole site's 5.7, but they've only excavated 4.8. Then you've set aside a consent judgment that's totally consistent with state law, even though DEP says, actually, they're totally fine. That's a result that could happen here because the issue's not adjudicated.
Thank you, Counsel.
Thank you. We'd ask that you affirm.
Attorney Huff, you've reserved 3 minutes.
I would like to just address briefly just two issues. One, if we'd known that it was in dispute somehow that the size of or the acreage of the excavation extraction was less than 5 acres, we would have introduced evidence relating to it. But here, that argument was never brought up before, and it's part of the factual record in that it's a finding of fact.
Well, do you have the right to introduce evidence on any point, frankly? I mean, you were granted intervener status in this case, but for the limited purpose of being heard, essentially, as to or objecting to the consent decree. I mean, is it appropriate to have an intervener on an 80K otherwise?
I think in terms of understanding the sufficiency of the consent judgment, it's and this question of applicability, I think it's possible that to ensure that the consent judgments are consistent with Pike, I think it's possible that you could introduce evidence to relate it to the limited question of whether certain statutes apply.
As an intervener, your interest is only in making sure that the consent judgment is consistent with Pike. Is your interest any different than that of a member of a public? Why would you have intervener status?
Our clients have intervener status in part because they have a direct property interest in the right-of-way that abuts and is next to the berm described in the consent judgment. That potentially
is there any interference at this point with the right-of-way? I understand visually you can see it. Is there an interference with the right-of-way?
The notice of violation noted that there was the potential to destabilize the road and the right-of-way. So the fact that it was necessary for us to be joined, and certainly our interests are distinct from those of the town. So in terms of intervener status under Rule 24, we were a necessary party to this case. Because, and then second, I just would like to emphasize that here we know or incorporating this sort of nuance related to enforcement into Pike would be a significant rewriting. If we know a state statute or some other authority applies, it's necessary for that consent judgment to at least be consistent with that minimum requirement.
But we don't know if it applies, right?
Here we do, because it's basically a stipulation within the findings of fact of the consent judgment, and you can.
So your position, your argument basically hinges on that there was a stipulation as to the size of the excavated area.
Right. The fact that it was included indicates that we, at least in this case, other cases there could be other statutes floating out there that we wouldn't. But in this case, we know, and it's a concrete issue of we know there's applicability.
Can I follow up?
You may.
What relief are you asking for?
We're asking for the court to vacate the district court's decision and direct the parties to reach an agreement that is consistent with the minimum standards of 50-foot buffer.
Not a remand for
for
some findings.
No, this was a limited legal issue. It's inconsistent, and so therefore vacating is the correct result.
May I ask a follow-up?
Go ahead.
Did I miss something, though? I thought earlier on in this session there was an acknowledgement that there is not necessarily an equivalency between affected area and excavated area. Am I wrong?
I think that the affected area and excavated area, those are the same things. There's been no dispute.
On what basis do you believe that?
there's been no sort of basis to suggest that there's been anything other than excavation going on. And so that idea, the fact that there might be some difference between affected and excavated, the use was excavation, extraction of gravel. And so therefore, the affected area is the area where it is greater than 5 acres, and so we know this applies. Thank you.
One more. I think it's hopefully easy. Did the town argue below that 490D standards don't apply? Or was it assumed that they did? And do you recall?
I think they just sort of left open into the air whether they applied or not. We do know they apply. I think.
But they've never conceded that they apply.
I think they sort of say within in the consent judgment itself. I think they name the like 490D as a potential, but that they leave it open to the DEP basically, and just as to whether it applies, and therefore the DEP could take enforcement actions. So somewhere I think in the consent judgment, it notes something about those statutes, but doesn't make a direct, or just sort of leaves that issue open. Thank you.
Any additional questions from the bench? Thank you. As is our usual practice, then, we will be taking this matter under advisement and issuing a written decision in due course. It is also, I understand, Mr. Hull, your first argument in front of this court. I sort of always feels like a return to the court. And as is our custom, we would invite all counsel, back to take the greetings of the court. Good morning, you can be seated. The matter before the court is State of Maine versus James Footman Jr. This is Andrew Scoggin, 25 and 463. I see counsel are present. Presumably you're ready to proceed. We are being streamed both by audio and by video on the web. And I would ask before we begin the argument, have counsel identify yourselves by saying your names for the record together with the party you represent.
Good morning. Rory McNamara for the appellant, James Footman Jr.
Good morning. Alexandra Winter, Assistant District Attorney for the appellee. Thank you.
And Mr. McNamara, we're happy to hear your arguments this morning.
Thank you. May it please the court, Attorney Winter. In the appropriately named Footman case, we have shoes that aren't that unique and utility knives that aren't that unique. Neither are so idiosyncratic as to suggest that only the one same person would commit two robberies with them.
Well, since you've let the green light be on right away, can I move to a different issue?
Yes.
Which is in the sentencing, talking about the basic sentence in this case. One of the factors that the judge pointed to was the use of a weapon, which of course was an element of the charge. In general, how is a judge to deal with that? In other words, if the legislature has essentially already said this is an aggravating factor, use of a weapon or something like that, that is going to increase the sentencing classification, right? But it, in fact, as a factual matter, is what makes this robbery worse than one where there isn't a weapon. I mean, this is actually a very broad and open-ended question because it frequently happens. You have an aggravated drug trafficking based on a prior conviction. Can you use the prior conviction as an aggravating factor in conducting the sentencing analysis? Now, in that case, there would be a mandatory minimum sentence, but which is not here. I mean, how is a judge in general to deal with that in setting the basic sentence when the factor which does make it perhaps more serious is one that is also an element of the increased classification for the offense?
Well, to the extent that element changes the class, I think you have your answer there, of course. You're going to be considering beyond that into a new class. But to the extent it stays within the same class, I don't think that's a proper consideration in and of itself. The nature of, in this case, that weapon, how it was used, may exacerbate properly at step one a sentence.
So it would be your position because the use of a dangerous weapon was an element of the offense. It can't be used to say it's more serious because of that.
Correct.
In the basic analysis, as opposed to how one uses the weapon.
Correct, and I haven't looked closely enough at the robbery statute in preparation for today, but my recollection serves there are different ways to get to a Class A, and one of them is use threatening a weapon, whereas others, I can't recall whether they are. And in that sense, you might be able to exacerbate a sentence at step one because one is worse than the other type of element. But here we have the use of the weapon that was charged, and certainly that was the gravamen of the state's case.
On a related point, you argue that in setting the basic sentence, you say, respectfully, the court markedly overstated the seriousness of this offense.
Yeah.
So that's your opinion. Mm-hmm. Okay, why should your opinion override the judge's finding during sentencing?
Well, in order for it to work, the continuum of seriousness has to be objective. If it's subjective, it simply won't work. And I think we have good indicia here of that, a lower class, a lower tier. First off, we have the state's position that this is a maximum of 10-year basic sentence. So that's good indication, number one. Number two, we have the duration. Number three, we have $50 taken, and the legislature has pegged robbery via the incorporation of the theft statute to denominations of how much was taken. We have motivation. This was not a get-rich scheme plan designed for commercial bank robbing or something like that. It was fed by addiction. The cashier said, you know, at first he came in and I kind of laughed at him. and then gave him $20, gave him a few more dollars after he put his weapon off to the side, which is different than going into a bank, of course, and shooting an AK-47 into the roof with multiple potential victims. So I think there are really objective indicia here of this being a low-tier offense. And of course, that's what the state felt it was, that's what the defense felt it was, and that's appropriately at step one is minus 5 years.
You're saying that that they weighed it too severely in the basic. So that's a propriety argument, correct?
You know, this is a gray area, as Your Honor knows.
This is why I'm asking.
These are serious questions we're asking.
It is set up as in this case, as a propriety of the selection.
And we granted the discretionary appeal.
Correct.
Should we look at propriety issues where we grant the right to appeal under an abuse of discretion standard?
Well, I think that the whole sentencing appeal scheme is really based off of de novo review for misapplication of principle, if those two terms can even kind of coexist. Principles are, in some nature, going to be discretionary, in particular when we have a scheme that has multiple different principles in there. But I think when we're talking about something as basic in there as the selection of the seriousness of the crime, as opposed to I prefer, to think about one element of aggravation or mitigation in a different way. When we're thinking about that continuum, it very much is this court's job and prerogative statutorily to say this is more serious than that objectively. And
So
we've got.
what's our point of reference? I mean, is there any body of case law, or do we just use our own imagination to think what it was like to be threatened with a utility knife by a somewhat unstable person? What's our point of reference when we address propriety?
Well, I'll put aside the indicia here that I do think are rather objective in this case, and they won't always be that clear. I understand that. And this is a problem in Maine, as Your Honor knows, more in the realm of proportionality analysis, but it's very related to this. And that is a sorely needed asset that we need. It's really a requirement when we're talking about what federal due process requires, forget for a second state due process, the ability to vindicate your constitutional or your statutory, in this case, rights. And if we don't have the comparative data because it hasn't been maintained, I think the judiciary is in risk of being in violation of all kinds of provisions.
We don't have that database, and probably won't have it in the near future. With that missing, what do we glom onto?
Well, I think you have to go with the benefit of the doubt. And benefit of the doubt, certainly in this case, is the state saying this is a 10-year maximum sentence, but also those indicia, and that maximum basic sentence.
Well, then let me ask you a slightly different question, okay? Putting aside the aggravating factors that the judge referenced of not showing remorse or taking responsibility. So let's put that one aside for the moment. In this case, the judge set the basic sentence at 10 to 15, which you are asserting is high, but then talked about aggravating factors and the criminal history in this case, which the judge certainly appropriately referenced, is quite significant and long. And one could suggest that could have aggravated from the basic to the maximum by quite a few years. And in this case, the judge landed on 12 years as the maximum when she set the basic at 10 to 15. Would we even assuming there was grounds to do so, would we reassess, if you will, the basic if indeed the maximum, i.e. the sentence that she landed on, is not inappropriate? Do you see what I'm saying? I mean, I think you could have aggravated this by quite a few years based on that criminal history. So even if it were, 5 or 6 or 7 as the basic, I think, couldn't the judge still have landed on 12 in consideration of those aggravating factors, the proper aggravating factors?
And I think there is a difference. between aggravating and mitigating factors and the selection of those, which is not, it is somewhat in the eye of the beholder. And that is why this court has reviewed those determinations for abuse of discretion traditionally. And that is different than this objective continuum of seriousness. I think that this court has to guard very much as a matter of statutory law, but also constitutional proportionality analysis. So when maybe the identification, and this is where maybe I would break down on that answer, the identification of something as mitigating or aggravating should objectively be the same from one case to the next in a categorical way. So addiction, typically, unless there are extenuating circumstances, is going to be objectively mitigating.
But conduct committed as a result of an addiction may still be aggravating.
Right, and here I'm just referencing not particularly this case, but how you would approach that categorically, but to the extent at which it is. And I think that's important for this court to say as a matter of principle, that this is something that is objectively, typically mitigating. And you can say the same, of course, it has with essentially with the short sleeves factors that we have. These are typically aggravating as a matter of law.
What level of deference are we going to give to the judge here? I mean, if we look at it and say, it seems a little high, but it's not outside the circle of discretion, it's not outside of the realm of reason. What's the level of deference we need to give to the court?
Are we talking about
the basic sentence?
The basic sentence. I think very little. Right, in a case like this, where there are, again, the state's representation and the defense representation about what was an appropriate sentence, but also the judge, and I don't have the language right in front of me, saying that this was a mid-tier, essentially.
Moderate, I think was the word.
Thank you, Your Honor. Sentence where that is something that is, we're thinking about 1, 2, 3. It sticks out as kind of a sore thumb. It's a black letter. That shouldn't be the frame of reference for where we're at.
In the old days, when Huey first arrived, a lot of us were using quadrants. We were dividing the maximum into 25% gradations. Is that a flawed practice?
I think it's a fine way to think about things. Of course, you're going to have to titrate within that, given the factors. It's not really about, I suppose you could have that theory, you could have a different theory. It's just about getting in the ballpark. And that's what the legislature wanted, I think, when it enacted this sentencing appeal scheme, was for this court to say, look, we realize there's a lot of discretion and there's a lot of subjectivity in sentencing. We're trying to get away from that. We're trying to have this court be the arbiter with 7 judges up here as opposed to 1 in the trial court to say, no, we think there was even a small deviation, but a deviation nonetheless.
I'm going to take advantage of my prerogative as chief and ask one more question, returning to the issue that you started with, which was the admission of the evidence of the 7-Eleven robbery.
Thank you.
And my question to you is this. There is something in the record that is suggesting that he has now pled guilty since that trial to that robbery. Does that, even if it is error, or it was error, to have admitted evidence of that robbery, does that make it now harmless?
No, and in fact, I think this is almost underscoring why that is the wrong evidentiary ruling. If Mr. Footman were to go back on remand, as I think he should, that evidence of whatever happened at that Rule 11 would now be admissible for him to say, no, I didn't plead guilty because that was me. I pled guilty because I got concurrent time offer. I would have been a fool not to take that, especially given my criminal record. I already have felonies. What does it matter? So it opens up a trial.
So do we let that play out essentially on remand, i.e., for example, if we were to vacate and remand it for new trial, one outcome could be he again pleads guilty for 10 years concurrent with everything else.
It may very well be, but I think
And we just let that play out is your point.
Right, and I think that I don't know all the facts. I haven't spoken with him about why that happened, but my reading of that was that's a very likely scenario. People we know, of course, plead guilty all the time for things as a matter of mitigation of risk.
Any additional questions from the bench? Yes.
Could these two, assuming he hadn't pled guilty and he's, we know he's charged with both, could they have been joined for trial?
I haven't thought about that, but theoretically on paper, I don't think that there would be an issue probably for joinder.
If it's a common scheme.
If it's a common scheme, right? And
So doesn't that suggest that even if there might have been didn't squarely fit within 404B, that there could be sort of harmless if they could have been tried together anyway?
No, I don't think so. Here we have the issue of one conviction, and then we have a separate case which, if had ruled for the defendant, if the court had ruled for the defendant, would not have come in. And there was, I think, a separate strategy as to how to deal with that. Whereas in a joinder case, you're going to be prepared to meet both. And here we had a ruling that was on the day of, or the day immediately prior to trial, where you're preparing and perhaps not prepared to defend against both of them in the same way.
And your position also is that the state has waived any harmlessness argument?
Yes,
is that right?
it is. Yeah, I didn't see it in the brief.
Okay, thank you.
Thank you.
Any additional questions from the bench?
Thank you.
Thank you.
Megan. Chief Justice, Associate Justices, may it please the court. I did not reserve any time, but I'd just like to pick up that last conversation. To the extent necessary, the state does not concede, certainly, that there was harmless error here.
Didn't you already concede error, that it couldn't be harmless if it was error by not arguing it?
No, Your Honor. I would disagree with that. The state does not concede that it was error to begin with.
No, I understand that.
Precisely. And so the state would suggest that even if this court were to find that it was error, it is certainly harmless error. The state would suggest.
Let's go to the error and whether it is error. What the purpose, I understand, that you put in evidence of the 7-Eleven robbery was to prove identity of the defendant, right?
That's correct, Your Honor.
So by putting in evidence of another crime that had a similar modus operandi or a similar idiosyncratic way of being committed, what you're saying is he committed this robbery at the 7-Eleven, that was very similar to the one he's now being charged with the Big Apple. Therefore, you should presume he also committed this one, or you may infer that he also committed this one. That's the argument, right?
The argument is that because, in terms of the evidence that was submitted for the Big Apple robbery, there was very limited evidence that was admitted and played to the jury of an additional person who committed a robbery of the 7-Eleven mere days later.
And how does that prove that it was this defendant that committed the Big Apple robbery?
Because the nature of the offenses were so similar.
It proves perhaps that the same person committed both, but how does the admission of the 7-Eleven robbery prove that that person is this defendant?
Because when Officer Nixon saw this person a few days after the 7-Eleven robbery, he was wearing the same shoes.
Which is why we can presume that this is the person that committed the Big Apple robbery.
Correct.
But the video or the evidence from the 7-Eleven robbery, how does that show that it was Mr. Footman that committed both of these robberies as opposed to someone else?
Because it depicted a person who was of similar build, wearing the same shoes.
But isn't it even weaker for the jury to infer? I mean, for it to be relevant, doesn't the jury have to infer that indeed this video shows Mr. Footman, and because the Big Apple robbery is similar, it also is Mr. Footman? I mean, that's what it's used for.
Yes.
But there is no independent evidence that the 7-Eleven robbery was indeed committed by Mr. Footman, other than the same evidence that you were putting in to suggest that it was him on the Big Apple robbery.
And, Your Honor, case law does not require that it does.
Of course it does.
In Connors, there was no evidence that the same individual had committed the second burglary. In fact, he was never convicted of that. That matter never went to trial, and there was no independent evidence that it was, in fact, Mr. Connors who committed that second burglary.
Well, I thought there was a confession.
I'm sorry,
Was
Your
there
Honor?
wasn't there a confession in Connors?
There was a confession that was offered to, I believe, a cellmate, and the evidence was admitted to, in the second area, to support that relevance. But the primary reason it was admitted in Connors was to support the fact that it was the same person. And so this case is directly analogous to that.
Well, counsel, is your position that if the prosecution wants to put in evidence of an uncharged crime to prove the identity of the person who committed the charged crime, they don't have to offer any evidence as to the identity of the person who committed the uncharged crime?
Independent evidence.
Independent evidence. I believe independent evidence is required.
And so what was the independent evidence in this case that it was Mr. Footman who committed the second robbery?
The fact that he was of the same build, wearing the same shoes, carrying the same black and red box cutter that was distinct.
And how do those inferences then allow the jury to conclude that therefore, as a result of that, it must be Footman in the Big Apple? It's circular. You're arguing the same thing.
Because he was in possession of those same items on a different occasion when he was.
There's no doubt about that. I think we all agree that the apparel and the modus operandi are all the same, but it's my understanding that the black letter law says that if you want to put in evidence of another bad act, that's ordinary, that's pretty verboten, because you don't do that because it's very prejudicial. But in that second act, if you know that's Jones and you can tie it into the case you're trying to prove, it comes in, despite the fact that it's prejudicial. But there has to be evidence on that other one that it's in fact Jones, and that's what opens the door to put it in to the trial of the principal case. I think what the chief, what everyone's getting at is, as regards that second on the 14th, I believe, we don't, there is no independent evidence. There's nothing that comes before the court or the analysis that says, oh, that's Footman. Whoa, and it looks just like the guy that did this, so that must be Footman. So you're basically riffing off the second one to prove identity in the first one. I think that's what the rule is. It's kind of, I think you're saying because you know it was Footman in this one, and it's the same stuff, that sort of trying to bring it back around. And it just, it's not what I understood the law to be. Am I misstating anything?
Well, Your Honor, my understanding of 404B is that it does permit evidence of an uncharged, possibly uncharged conduct to prove the identity.
It does.
Identity,
of the
correct.
person who's on trial today.
Right.
But in order for that to come in, you have to have that evidence of identity established, and then absolutely it would come in.
In other words, you have to have evidence normally that says, you know, Mr. Jones has committed these 10 burglaries, and he has this really unique way of doing it. You know, he flies in on, a foil and comes in through a roof and, whatever, something very unique. Now we have before us, and we know Mr. Jones did that because whatever, he was convicted of it. Now we have before us yet an 11th robbery where somebody flew in on a foil, came in through a roof window and did all exactly the same things. You can infer it was Mr. Jones who did that because we know it's Mr. Jones that does these other robberies. I mean, that's the 404B.
Well, the jury in this instance was only being asked to consider whether or not it was in fact Mr. Footman who had committed the Big Apple robbery in particular.
But that's the problem. First, if the second robbery is going to be helpful to the jury in determining identity, then it has to have been Mr. Footman who committed the second robbery, right? And so I guess...
Do you agree with that statement? You may disagree as to whether that inference is there, but you agree with that statement?
I do, Your Honor.
Okay. What standard of evidence should be applied to the question of whether there was enough for the jury to conclude that Mr. Footman committed the second robbery?
I think ultimately it would be a sufficiency of the evidence argument. However, as we've alluded previously, Mr. Footman has now pleaded guilty to that particular robbery.
But he had not at the time, right? I think certainly you'd, be in a different position if he had pled guilty to that. But basically you were in the position of using the same after the fact interaction with the police to try to convince the jury that Mr. Footman had committed both of the robberies. Isn't that correct? There was no better evidence that Mr. Footman committed the second robbery. Is that true?
That's true, Your Honor.
Go ahead.
Can I follow up on that then? Let's assume, just assume that that was improperly admitted. And assume that you haven't waived an argument about harmless error. Why would that admission of a second robbery, if it wasn't properly admitted, do you assert that would be harmless?
I do assert that would be harmless, Your
And
Honor.
on what basis?
Because ultimately, the jury was asked to consider whether or not the individual that was depicted in the Dave's Place video, which showed the individual who committed the Big Apple robbery moments before unmasked, ultimately the question for the jury was to determine whether or not that same individual was Mr. Footman, and they were given.
And you don't think there's any chance they were unfairly prejudiced by being told, and by the way, we also have a guy who commits another robbery, he's pretty much a bad dude?
No, Your Honor, because the evidence boiled down to whether or not this was in fact the same person.
So it wouldn't matter if you put in any number of other incidents improperly, as long as they're told, well, we're really only just talking about this one.
That was essentially the entire basis of, in my opinion, the determination that the jury was able to make, that it was in fact Mr. Footman who committed the robbery.
As I understand it, the evidence that went to the jury upon which they could conclude that it was Mr. Footman who committed the 7-Eleven robbery was that after that robbery, he was observed by police officers to be carrying that box cutter and to have shoes similar to the person who's depicted in the video of the 7-Eleven robbery. Is that right?
It was of the same build and stature in the same area mere days later.
And so wouldn't it have been less prejudicial simply to have had the evidence submitted? For example, the officer could have testified, when I encountered Mr. Footman, this is a picture of the box cutter he was carrying, and this is a picture of the shoes he was wearing, and then the jury could have compared that to what they saw on the video of the Big Apple robbery.
Well, and that did occur as well, Your Honor.
Well, except in addition to that, there was a video put in of someone committing a second robbery. And so
yes.
Isn't it a lot less prejudicial simply to let the jury see the evidence that ties him, rather than also putting in the evidence of him committing another crime?
Well, again, it was submitted for a relevant purpose to prove identity in the state's opinion. And my understanding is that the standard is not whether or not it was prejudicial, but whether or not it was unduly prejudicial.
But undue prejudice also, we also consider whether there are less prejudicial ways of doing something, right? Doesn't that fit into the analysis of undue prejudice?
Well, and here the trial court weighed precisely that. They determined what evidence would be admitted. It was very limited evidence. The trial court determined that any reference to what charges, if any, or the fact that he had been charged with the second robbery would not be admitted. And so they balanced those factors accordingly, and that's why it was permitted to be admitted.
Could these have been joined for trial?
I think so, yes.
Does that support an argument that even if this shouldn't have come in, it's essentially harmless because they could have been tried together?
I think certainly, yes, Your Honor.
Go ahead.
Isn't the evidence of Footman being the perpetrator of the first offense there? It exists, and it would be powerful on the second prosecution to say, we identified him in this here, and so we'll use that. But this is flipping it. This is saying, we have evidence of him doing the first one, none of what happened in the second one, but he must have done the second one because he's the same person. Isn't that circular?
Well, I think if these matters had in fact been joined, then I think all of the evidence could have been tried to a jury, much more than was admitted in this case. And I think ultimately the same question would have gone to the jury at the end of the day. Is this in fact the same person? And the evidence still would have been the same, whether or not...
It would have been the same, but the jury here is hearing, okay, well, we got some evidence here that Footman did this. Whoa, he did a second one too, so we better convict him of this first one because this guy is a problem. It's propensity evidence. This guy commits armed robberies using his knife. Isn't that terribly prejudicial?
Propensity evidence is not allowed under that purpose, Your Honor. But in this case, the evidence was not admitted for that purpose. It was admitted for the purpose of
But isn't the
identity.
point of 403 that unduly prejudicial is that there is far too great a risk that it would indeed be used for the wrong purpose and would, in fact, allow the jury to decide a case on an improper basis?
And I think that's why a trial court is obligated to undergo that analysis in a bifurcated fashion, which the trial court did here pursuant to motions in limine. We had a separate hearing on this particular subject, and that's why the trial court analyzed it as it did.
But is 403, if it's not admissible in the first place, I mean, 403 isn't the proper analysis. 403 assumes it is indeed relevant and admissible. You only get to the question of undue prejudice if it's admissible, right?
Yes.
Is the issue on appeal, in other words, if we were to say that it was not admissible in the first place, then what is the analysis?
I think that would fall under whether or not this was a clear error, is my understanding.
And if we say it is, what is the harmless error analysis?
Well, the harmless error analysis is, again, that the evidence in the state's opinion focused on whether or not this image of the individual immediately prior to the robbery was, in fact, Mr. Footman.
In the 30 seconds you have left,
Of course.
Mr. McNamara says that the court overstated the seriousness of the offense in the first Huey step. I take it you disagree with that?
I don't.
You don't?
When we're considering a Class A offense, the maximum sentence is 30 years. And so in this instance, the state and the trial court, I think, very properly found that a basic sentence was only a third of that, of 10 years. And as Chief Justice...
10 to 15.
10 to 15.
But you're saying
and the
that's
state's
an appropriate-
recommendation was 10, if I remember
That's an
correctly.
appropriate basic sentence based upon these facts.
In my opinion, yes, it was.
What deference do we owe the states, or the judges' position that that was an appropriate sentence?
I would suggest to Your Honors that that would be an abuse of discretion analysis. I think it would be very difficult for this court to undergo an analysis of every single sentence that was imposed. We ask that trial courts impose reasonable sentences based on their analysis, and I think that that's what happened in this instance as well.
Any additional questions from the bench? Thank you, counsel. Attorney McNamara, you have 3 minutes.
Thank you. If I may, although Justice Meade somewhat stole my thunder, I think, I was hoping to address...
I did respectfully.
You did. Thank you, respectfully. I'd like to address Justice Lopez's question about joinder as it touches on harmlessness with a step back of saying some of this is difficult because the state didn't brief harmlessness, so I'm coming up with argument now here.
Well, isn't the response to joinder, I mean, part of your argument was that there really isn't sufficient evidence of a unique or idiosyncratic method,
Course of conduct.
and that a joinder of the two would, in fact, require proof of a common scheme, which is a similar kind of thing, and I think you've really argued that there really isn't.
Right. Getting over that hurdle, I think there's more to it. So in a joinder case, the jury is making its determination as to each count separately. Here, we're using proof of robbery number 2 to prove robbery number 1. It's almost the propensity inference, as Your Honor said, exactly. And if we look at the closing argument of the state, if you find that this is the same man, then this defendant is guilty of these facts, and you should find him so, of those combined offenses. We get instructions, juries get instructions in the typical case, and they probably would have in a joined case, that you're to make a determination as to each charge separately, to each count separately. That's the exact opposite of what we had here, where we had not only we have an invitation to consider number 2 as to number 1. We have no specific unanimity to separate one as to another. We don't know. It's a patchwork verdict, as I've heard before.
And no burden of proof as to number 2, right? So the jury's not instructed that has to be beyond a reasonable doubt, as it would be if they were joined for trial.
That's a good point as well, right? We can use proof as to something that's proven to whatever standard over there as proof of this over here, of the charged offense. The state, of course, is correct. This is a Class A crime, a Class A offense. That's not the question. Is it among the most serious Class A offenses, where, again, use the hypothetical of a band of bank robbers going in and shooting up a bank? We have nothing like that, taking away $1 million. We have a low-tier, 10 years minus offense that is just, it's not as serious a Class A offense as we have typically. And that's all I have, if there are no further questions.
Any additional questions from the bench? There don't appear to be. Thank you. Thank you, counsel, for the argument here this morning. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. With that, we will be in recess for the morning.
All rise.